Hey, Cypher here, and today we're going to talk about the Second Amendment. Since it's been coming up in the news so much, and since people want to talk about the actual amendment a great deal, I figured we would talk about the actual historical context of the Second Amendment. Now, it's important to note that there are a lot of opinions to be had about the Second Amendment, but there is one opinion that rules over all the rest, and that is the Supreme Court's. It is their explicit part of our government to rule whether or not something is constitutional or not, which also means that they have the ultimate opinion on any given subject in the Constitution, which includes the Second Amendment. So we're going to talk about what they have historically ruled on the Second Amendment. They haven't talked much, but there are 5 cases that we need to know specifically about. But first, what does the Second Amendment specifically say? It states that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, there were several cases early in the court's history that actually ruled about this, but we're not going to look at them because they really don't matter. It was in 1875 that the Supreme Court held the first case that actually matters towards the Second Amendment on the Second Amendment. It was U.S. versus Cruikshank. It was specifically about Southern states depriving blacks of the right to bear arms. It was an extremely racist law to begin with, and the Supreme Court wasn't exactly not racist itself. They ruled that the Second Amendment only applied to the federal government and not to state governments in themselves, since it was the state that would regulate a militia. Now, in 1886, in Presser versus Illinois, the Second Amendment came up as an individual right. The Supreme Court held that it was the people who held the right, and not the militia itself, irregardless of military service. Now, a lot of people mistake that the militia part of the Second Amendment has to do with the actual militia itself. In this 1886 ruling, the Supreme Court held that it has to do with the ability to be in the militia and not being in the militia itself. Then, in 1939, U.S. v. Miller happened. Because of a recent gun law in 1932, the Supreme Court had to rule on a case about a sawed-off shotgun. Miller was caught with one in the trunk of his car. They ruled against Miller, stating that since the sawed-off shotgun is not a military-used weapon, that he had no right to have one. Though one can make the argument that the Master Key shotgun would actually overrule this ruling, but specifically U.S. v. Miller stated that it was about the individual, so it actually ruled out the ability for the Second Amendment to apply to explosives. There wouldn't be a concise ruling until 2008 with D.C. versus Heller. In Washington, D.C., they had actually abolished pistols, and the Supreme Court overruled that for all federal enclaves such as Washington, D.C. This represented the individual right in federal enclaves, but it still did not represent states. We had to get until 2010 with McDonald versus Chicago. This overruled the 1875 ruling, extending the Second Amendment under the 14th Amendment to the states. It also said that the Second Amendment specifically related to self-defense as well. Overall, it is the court's view that in order for the people to maintain their ability to be in the militia, they hold the right to keep and bear arms that are similar to what the individual soldier would carry on the battlefield, and that no government may infringe upon that. Now, that's not a complete win for the gun nuts, if you think about it. It basically means that gun owners have the right to 3 specific weapons: a military-style pistol, a military-style shotgun, and a military-style rifle. Nothing beyond that. So before you go around saying what the Second Amendment really means, get the facts right. Read the opinions. They're all in the links below. But what does that do to non-military weapons? The Supreme Court actually doesn't say. There's a lot of ambiguity on it. Tell me what you think. I mean, this is a very complex subject, and I can only give it to you in a very short burst. And next time I'll have another gun control episode for you. So don't forget to subscribe.